With your Lordship, thank you.
Yes.
I know I'm not in order in practice of this, but I'm constrained to move a matter because it concerns personal liberties accrued from illegal detention of certain employees in a hotel by the KSCD's Estate Corporation. And therefore, I'm constrained to move this matter so that preventive detention or illegal detention can be removed. Not preventive, illegal detention.
Where is your petition?
I filed it, Your Lordship.
You have filed it today?
No, Your Lordship, I filed it on 29th.
Tuesday. When it will come? It will come on
Habeas corpus. Habeas corpus or PIL?
No, it accrues from a commercial appeal, arbitration appeal.
It is an arbitration appeal, commercial court appeal.
Yes, Your Lord. There is no order of seizure, resumption of possession, but they have gone ahead and locked up the premises.
All right,
The
tomorrow.
employees being inside.
Tomorrow.
Lordship, I have one more submission to make. This bench may be disabled because my Lordship, Justice Krishna had appeared in one of the MFAs in the matter.
Which on that Bidar thing, is it? It has to come and then we'll have to say
Then
no.
only if anything can be done.
Much pleasure.
We'll move on. PS.
Give the details.
I've given the
Give the memo on that. Matter would be posted for tomorrow.
They are also taking up some movables today, Your Lord. That is my another problem.
Today it cannot be taken up. It can be taken up tomorrow. We'll grant you permission, only then it will be posted. It has to come up in the list and all that. Therefore, it will come tomorrow. But give the memo.
Yes, sir.
The respondent number 3 has constructed a building on the public property and a drainage and encroaching on the property. And we have complained to the local authorities, and in spite of not issuing of notice to the local authorities, he has not replied. And the local authorities have also not taken any action against the respondent number 3. Therefore, I have approached this on the report.
No. Yeah.
Where is the relief?
There. Even according to the petition averments, respondent number 1, the CMC, has already issued a notice to R3.
Yes, ma'am.
So they'll complete it.
He has not even replied. They have issued.
Right. They'll take those proceedings to their logical end. They have already issued a notice. They've initiated proceedings. That will be taken to its logical end, isn't it?
And why not I filed this petition not
Already initiated proceedings, they'll conclude the proceedings in accordance with law.
my submission is this as they have not as and when I approach the authorities
We will direct them to take it to the logical end. The notice which has been issued, they may finalize it and take appropriate decision in accordance with law expeditiously.
that liberty may be reserved if they don't do it within the time fixed by this on the report so fix it up
Then contempt.
and this is I have
This public interest litigation has been filed.
page number 30.
Notice. You accept notice? Notice for 1 and 2.
CMC, city municipality. So, and panel council.
Some of the Is there any counsel for CMC Raichur?
Some advocates appear in Gulbarga bench.
All right, all right. This public interest litigation has been filed seeking following relief. As per the own case, full stop, as per the own case of the petitioner, the respondent number 1 and 2 have already issued a notice, show cause notice to respondent number 3
3. That's it.
for removal of illegal construction made by respondent 3 over Raja Kalau situated near KSRTC subdivision office, Ashok Nagar, Zahirabad, RTO office road, Raichur. However, the respondent number 3 has not sent any reply to the said show cause notice, and as such, no action has been taken by the respondent number 1 regarding the alleged illegal construction made by respondent number 3. Since already the cognizance regarding the alleged illegal construction has been taken by respondent number 1 and 2, and a show cause notice has been issued in this regard to the respondent number 3. As such, we do not find it necessary to grant indulgence at this stage. The writ petition is finally disposed of with the observation that the competent authority may be respondent number 1, Commissioner City Municipal Council, Raichur, shall take appropriate decision in accordance with law pursuant to the said show cause notice, and what do you say? This, instead of decision, say action. And in the afterwards, write up and pass appropriate orders. Full stop. The respondent number 1 shall bring the show cause notice to the logical end expeditiously without undue delay. Full stop. The writ petition is finally disposed of.
Number 2, to engage Mr. Jia.
Yes, who appear for appellant? Nobody? Pass it over. Pass over.
Number 3,
Appeal under section 37 against the order under section 34, which will also find it annexure A at page 69. But there's really because like listed only 3 issues that arise. The fact was in brief with this. Appellate one is a trust which runs a school and was by an agreement which was dated 23/11/2012. Was appointed respondent to effectively operate the school. And there's a finding of the arbitrator that the respondent took over the management of the school. That has become final against him. But having appointed the respondent to operate the school for 20 years.
I had appeared for Pearson.
I see.
Please refer another bench of which one of us write the name of the brother. If not remember after obtaining necessary orders on the administrative side by the.
Maybe permitted to file objections minutes to the IFSC. I'll file objections to the IFSC minutes and maybe permitted.
But I understand that even till date, no execution proceedings have been undertaken.
Not filed.
Till that stage, will not let him not precipitate.
That there has to be a deposit to be made by the minutes.
I leave it here.
I can't say anything.
Let him file, because only a short issue arises. In fact, we can finish the main matter itself. Because there are.
This is a disabled matter of this bench.
I'm sorry. Hey, I quit.
Take the appearance of the council
Please.
and within up.
Number 4. Santayake.
My lord, at the time of filing his appeal, evidence name was not a big time.
Is there any scope of amicable settlement?
I have no issue if you can say.
Pay something and get rid of it. Only a small amount, 8,79,000.
Please, my lord, please.
Just sit together and
My lord, my submission here. I will deposit some amount. Clearly,
We'll refer it to mediation.
well, let him deposit 50% of the phone. Both agree, then we will refer it to the.
That's it.
You deposit the entire amount? That is why we were saying you sit and try to find out.
the very legal notice itself, I am disputing as invoices also. I am in, because of my business is a small business. In fact, I am not.
He is ready to still negotiate.
Please.
We'll refer it to mediations.
50%.
If mediation not required.
50%.
Please, my
And if both of you are ready, we'll refer it to mediation.
please, my lord.
It may be referred to mediation. I have no issue. Subject to that.
Heard learned counsel for the appellant and learned counsel for the respondent. Full stop. Matter requires consideration. Appeal is admitted. On IA number 2 of 22 for stay, the operation and implementation of the impugned judgment and decree passed by the commercial court in OS number so and so is stayed subject to the appellant depositing 50% of
Within
the
2 weeks.
50% of the decretal amount together with up-to-date interest within a period of 2 weeks from today. Full stop.
Saying that your mediation would be delayed unnecessarily. Why you want to delay the matter? You deposit, it is only a small amount.
Please, my lord, it is for arranging the
You deposit within 2 weeks, thereafter the matter would be referred to mediation. And the outcome of the mediation would be placed before us. We will make it time bound for the mediation also.
Within a period of 2 weeks
weeks.
from today, relist on date.
No, send it after deposit, the matter may be
Right.
paid before.
Immediately after deposit, the both both learned counsel for both parts, for appellant and respondent jointly submit that the matter may be referred to mediation. Full stop. Submission is placed on record. After the amount is deposited as stated supra, comma, the registry is directed to refer the parties to mediation by fixing the date of appearance before the mediation center as 21/4/2022.
So that's fine.
3 weeks. 3 weeks.
Number 5, manipulate of
what's accommodation till next week. This is an application filed under Order 13, where a summary judgment was passed based on an application, despite issues already having been framed. The trial court has relied on certain documents to pass this decree. Now, my lords, I am not in a position to file certified copies of the same because those documents were not even marked in evidence. So I would have to produce those documents before my lords so that my lords can
What were the
consider.
proceedings?
My lords, the admission denial, my lords, of the documents were not filed before the trial court, my lords, and leave thereafter, my lords, was not sought to recall the stage, my lords. On the admitted documents, my lords, the summary judgment has been passed, my lords. The stage was for filing of the admission denial statement, my lords. It did not come to be filed with the defendants, my lords, therefore it was closed. And the stage, my lords, thereafter came for consideration for summary judgment. Even at that stage, my lords, the defendant did not seek the leave of the court to file the admission denial statement, my lords, thereby forfeiting their rights. My lords, the documents which were admitted in the suit, my lords, summary judgment has come to be passed, my lords.
If I may, my lords, based on documents, merely because I did not undergo this process of admission and denial, the trial court has taken it saying that all the documents are deemed to be admitted. Now, that's the very invoice which the trial court relies on as an endorsement saying that this needs to be verified, we are not admitted. Therefore, my lords, I need to place those documents before my lords. Unfortunately, I wasn't able to get certified copies because they are not being marked.
What is the nature of the case?
Commercial code summary.
Order 13A. Order
Right, my lords, if I may,
But your objections, page 82. You appear for D1, D2, and D3.
at this stage, I appear for all the respondents.
All the respondents.
There were two different counsels appearing for the respondents to the appearance before the court.
Defendant 1 and defendant 4 have filed separate objections. But
1 to 3 reports. In fact, that's
no, what is it you have said in the objection? Except denial, nothing else is said. That is the issue.
Lots. We will then have to consider whether the documents which have been filed along with the plaint will actually make out a case or not.
Correct.
That is the point which I am also trying to make.
Right.
Upon consideration of the very documents, firstly, because all of those documents are seriously disputed in the written statement. Secondly, those very documents, there is an invoice which is produced, which they rely on. The invoice itself states an endorsement is given. They say that it is admitted by me, whereas there is an endorsement given which states that this is subject to corrections and we are not even looking to it. This needs to be verified.
Commercial Code Act amendment.
Now, I will go ahead and address my arguments on this point. All I am seeking is I will not going to produce additional documents from my end. Let me rely on the documents produced by them, especially.
Just a minute.
Please.
Answer minutes has been answered by the court below minutes with respect to a decision of the Delhi High Court minutes where the minutes may pursue minutes to take the operative portion thereof minutes.
The judgments of other courts which have held once the issues are framed, the question of who is this narrative. Delhi High Court has held the court.
The provision says.
These minutes. I'll be able to demonstrate minutes in the light of minutes not filing of the admission denial statement and the documents minutes being admitted. Minutes the summary judgment application could have been minutes after the issue. Paragraph 50 of the impugned order minutes in fact addresses that contention.
Respondent, if they want to contest this appeal, then they will have to stay the order, right? When they respond, we will admit the appeal, defer, and thereafter correct. The second is if they agree with the party, then we must set up.
Come in the way. So you have two options. We set it aside and send it back. We decide for reconsideration, or you file your response. We'll have to stay.
I will file the response minutes. I'll also demonstrate how minutes. I will try to convince my
It will take time. It is your interest that get the matter remanded back and get it decided there. What is the point?
As a regular
this
suit.
summary judgment will have to be stayed here.
Minutes. It is a commercial suit. Minutes. It's not a regular suit. Minutes.
As a
It
commercial
is only in
suit,
commercial matters summary judgment can be
minutes,
given.
not by way of a summary judgment. Order 13 rule, order 13A, clause 2. Right. This application after framing of issues, that aspect requires
minutes. I'll file my response in minutes. I'll try to convince my lords as to how it would be weighted in minutes. Then minutes may I'll go on to what my lords would say. Minutes.
All right.
Heard learned counsel for the appellant and appellants and learned counsel for the respondent and peruse the material on record. Full stop. In addition to reiterating the various contentions urged in the appeal and referring to the material on record, the appellant, the learned counsel for the appellant invited attention to the proviso to subrule 2 of order 13-capital A CPC in order to contend that having regard to the undisputed fact that the issues had already been filed on, when is that? Issues had been filed on, framed on 12/3/2020 prior to filing of the application on 22/3/2021, the trial court clearly erred in decreeing the suit without considering or appreciating the aforesaid proviso to subrule 2 of order 13-capital A CPC, and this has resulted in erroneous conclusion. Per contra, learned counsel for the respondents seeks time to file statement of objections. That requires consideration, released in June. Meanwhile, the operation and implementation of the impugned judgment and decree passed to the commercial court is stayed till next date of hearing.
Minutes. The 13A minutes has been considered by the trial court. Project may be audit, my lords. And
ISO has not been considered.
Please, please, Sanket.
Number 6.
Seeking permission to withdraw this appeal with liberty to file writ petition.
Will not grant any permission. We will dismiss it.
The coordinate bench of this court possibly ordered. Those matters, me and my friend who appeared.
Yes.
Petition under the National Highways Act. Special Land Acquisition Officer Facility Award. Against which we filed application before the Deputy Commissioner with the sole arbitrator.
Right.
Against the Deputy Commissioner order, we filed an application under Section 34 of the Arbitration Act. Filed application before the district judge. Section 34 application could not maintainable. See the
Yesterday we passed on.
Yesterday we passed.
participants.
Not this.
It's fundamental.
3G, not yesterday, last week. Last week, under the National Highways Act, 3G. Yesterday we passed, sir.
We will dismiss it, not this.
Correct.
Leaving it open for the tape.
Correct. Yesterday, Lordship said was, they asked Liberty, then conversion, all that same matter.
Regarding solution is concerned, we not be able to find petition. Identical circumstances is one of the connected matter in those matters.
Good evening.
And number 10. Page number 35, paragraph number 10. The opposite decision taken by this court, enhancement of compensation sought by the claimant will not come within the purview of section. So on, so back. Last page.
On merits, this is dismissed. Where is it? Which on maintainability, is it?
I see them who appeared before the coordinate.
Appeals being devoid of merits stand dismissed. For last time.
Correct. On merits, not maintainability. This MFA was maintainable. MFA was dismissed on the ground.
Section 34 application.
Section 34
before the district judge.
Where is that finding?
Hello?
Where is the finding that section 34?
Page number 35.
It is not on maintainability. It is on merit.
Merit within the limited scope of section 34, therefore it is dismissed.
This is one of the connected matter in this.
Can I same per?
Please, same.
We will follow this and dismiss it.
Very well. Very well.
It cannot be dismissed as not pressed. It will be dismissed on merit following this judgment, and the liberty has been given to appellant claimant to seek redressal of their grievance in accordance with law before appropriate forum.
Please.
You may do whatever you feel like. We do not know what remedy is available to you.
We will do the same thing. We will place on record his submission that this appeal is directed against this appeal by the appellant in AS number 6 of 2018 on the file of the 3rd additional district at Shimoga is directed against the impugned judgment and order dated 29/3/2019, whereby the said application/appeal filed by the appellant under section 34 of the Arbitration and Conciliation Act 1996 was dismissed by the trial court. Full stop. Heard learned counsel for the appellant and perused the material on record. In addition to, in addition to reiterating so on. So learned counsel submits that under identical circumstances, a coordinate bench of this court in the case of H.C. Kumaraswamy versus Special LAO and others, in an MFA 5302 of 2019 and connected matters dated 19/7/2021, has dismissed the said appeals as devoid of merits, reserving liberty in favor of the respective appellants / claimants to seek redressal of their grievances in accordance with law before the appropriate forum if they are entitled to and advised to do so. Full stop. Full stop. It is therefore submitted that the present appeal also deserves to be disposed of in terms of the said decision. Dismissed, reserving liberty in favor of the appellants in terms of the said decision. Full stop. Submission of learned counsel for the appellant is placed on record. Full stop. Accordingly, the present appeal is also dismissed as devoid of merit, reserving liberty in favor of the appellant / claimant to seek redressal of his grievance in accordance with law before the appropriate forum if he is entitled and advised to do so. Quoting that. Citation, the judgment.
No, the relevant paragraph.
Relevant paragraph. In the said decision, this court held as under paragraph 10 and 11. 9, 10, and 11. Extract.
Relying on
Correct. Associate builders, but it is wrong. Wrong in this sense.
No, it has been said that the section 34
Limits the appeal minutes under section 30. The arbitration association. Learned arbitrator minutes allowed my claim, holding that subject property is the property belonging to the firm. Honorable Court Millard has set aside, the Honorable Court Millard has set aside the award on 2 grounds. One, that the deed of dissolution that was entered into between the parties put an end to the partnership deed, and the partnership deed which contains the arbitration clause also died along with that. One ground, my lords. The other one is that the property which is the subject matter of the arbitration was not the asset of the firm is one other ground, my lords.
To a claimant.
Yes, my lord, I am the claimant.
Arbitration and solution. On what grounds has been set aside?
That the deed of dissolution of the partnership did not contain an arbitration clause. Therefore, my lords, the appointment of an arbitrator would not be proper. But it's my submission on that ground, my lords, is that the deed of dissolution, my lords, is a continuation or in a document that puts a name to the partnership deed. Now, my lords, the deed of dissolution clause 7 contained a clause which said, if there are any assets belonging to the firm, such assets shall be divided mutually among the parties. Therefore, my lords, the asset that I'm seeking for a claim before the learned arbitrator was an asset that acquired during the partnership, during the subsistence of the partnership. This asset, my lords, I sought for an adjudication that it belongs to the firm and I'm entitled to 50% share as per the partnership deed. My lords, the learned judge, my lords, has come to a conclusion that the dissolution deed of dissolution novates the partnership. That cannot be, is my humble submission. Because of a specific clause in the deed of dissolution which said that any other asset that is found to be belonging to the firm shall be mutually divided thereof.
62 Contract Act will apply if the deed of partnership is novated and replaced. Doesn't apply.
Correct, Minister. 62 doesn't apply. Because this is not a
It is not a novation of the partnership deed. A
Yes,
dissolution deed cannot be construed as a novation of the partnership deed.
It is my ground, because the partnership is subsisting and a deed of dissolution also states.
You are claiming right under the clause number 7 of the dissolution deed,
Correct. Because it says.
which doesn't novate the partnership deed, nor does it extinguish the arbitration clause. And therefore, this finding is incorrect.
In the original partnership,
There is arbitration. Issue emergent notice to respondents. Heard learned counsel for the appellant and peruse the material on record.
Submission लिखा गया है.
In addition to reiterating the various contentions urged in the appeal and referring to the material on record, learned counsel for the appellant submits that the trial court, while dealing with the application/petition filed by the respondent number 1 under section 34 of the Arbitration and Conciliation Act 1996, committed a grave and serious error of law in coming to the erroneous conclusion that the partnership deed dated 1/4/2021, sorry,
1/6/1994 is a part.
1/6/1994, containing the arbitration agreement stood novated, and that the arbitration agreement stood extinguished by execution of the deed of dissolution of partnership dated 1/4/21 between the petitioner and respondent, appellant and respondent number 1. Full stop. In this context, it is submitted that execution of the dissolution deed between the appellant and respondent number 1 would not tantamount to either novating the substituting or altering the partnership deed dated so and so within the meaning of Section 62 of the Indian Contract Act, and consequently the arbitration agreement contained in the partnership deed would continue to subsist, and failure on the part of the trial court to appreciate this has resulted in erroneous conclusion. Full stop. Submission of learned counsel for the appellant is placed on record. Matter requires consideration. Appeal is admitted. Issue notice to respondent number 1. Notice to respondent number 2 is dispensed with. Registry to secure the TCR. Meanwhile, the operation and implementation of the impugned judgment and order. There's no interim order. But this is not stayed. All right.
My claim came to be rejected.
Number 8. If you see that,
For the appellant, my lord. Appeal under Section 37 of the Arbitration and Conciliation Act, my lords. Arbitration was initiated under the National Highways Act, my lords. The claimant has filed the claim statement before the arbitrator, which was barred by limitation, my lords. We have challenged that, but the arbitrator has allowed the claim and then award was passed. Challenging that award on the ground that it is barred by limitation under Section 34 was dismissed, my lords, against which this appeal is filed.
You are the authority.
I am the authority, my lord. In a similar matter, my lord, a coordinate bench of this honorable court.
That's right.
A coordinate bench of this honorable court has in
On
similar
what
matter.
ground you are challenging it?
On the ground of limitation, my lords, the claim submitted before arbitrator was barred by limitation, my lords. After expiry of 3 years from the date of award, the same was challenged. And arbitrator has, without considering the aspect of limitation, has passed an award in favor of the claimant, which was challenged under Section 34, my lord. But under Section 34, the trial court has failed to consider that the claim was barred by limitation.
Tell us the date of the award.
Please, my lord.
Tell us the date of the award.
Yes, my lord.
Date of the award
Yes,
is 22/9/2011.
2011, my lord.
11.
Yes,
So according to you, within 3 years from that date, 3G5 application had to be
that's right,
filed.
my lord.
Where do you get that? Which is the provision? National
There
Highways
is no provision for limitation under the National Highways Act.
Correct.
So the application of the Limitation Act under 137
137. right?
applies. That is covered by the decision of this honorable court. But what happened in this matter, my lord, is that we have not raised that ground of limitation before the arbitrator.
Even assuming 137 is applicable, what about Section 5 of the Limitation Act?
Section 5 will not be applicable, my lord.
Why do you say that?
Extension of limitation, because it is an original claim, like an original suit. It is a claim.
None. Okay.
And this honorable
It
court.
is not original, it's a challenge, it's an application. It's an application under Section.
Claim for under the Arbitration and Conciliation Act. Please, my lord.
National Highways Act. Limitation. Before we see that, we'll just see this. Please read 3G5. The amount determined by the competent authority
Under
subsection
one of
amount
3G.
on an application by either parties be determined by the arbitrator to be appointed
By the
by the central government. Is there any provision in the National Highways Act with regard to applicability of the Limitation
No,
Act?
no provision under the National Highways
No
Act.
provision under the Limitation Act.
National Highways.
Then subsection 6, subject to the provisions of this act, provisions of Arbitration Conciliation Act shall apply. So therefore, Section 43 makes Limitation Act
Limitation Act
applicable.
applicable, my lord.
Your contention is an application under 3G5
Should have been filed.
be determined by an arbitrator to be appointed, right?
Yes.
Now, how does the arbitrator appointed?
Arbitrator was appointed by the order of central government by a notification, my lord.
Right. Now, that order of the central government, if it is under the Arbitration and Conciliation Act,
Yes.
because of Section 43, 137 would apply.
Correct.
Now, if the appointment of arbitrator is not under the Arbitration and Conciliation Act, then section 43 will not apply. So if 43 doesn't apply, 137 will not apply. So if 137 doesn't apply, 3 years doesn't apply. So it has to be reasonable time principle.
Reasonable time principle.
Right. So therefore, limitation by itself. Allah, that's the position. Is that the position? That's the position.
In another,
We already taken a view, is it? We have issued a notice.
in this matter, it was considered that since the issue of limitation was not raised before the arbitrator, you cannot subsequently raise that issue before section 34 because it is not a continuation of appeal proceedings. It is a separate proceedings with respect to challenge, my lord. That is the.
Section 3 of Limitation Act, even if limitation is not taken as a defense,
Yes.
it has to be considered. This judgment is wrong. Of this. Arbitral award.
I think confirmed.
Correct. That arbitral award, application filed by the land loser for enhancement, that application is barred by limitation is the argument.
The claim itself is barred by limitation, is my contention, my lord.
Statutory arbitration under the National Highways Act. That's what, sir. If it is beyond limitation, the only question is whether it has to be 3 years from
The date of award.
pure legal issue.
Sure, legal.
Similar, we have issued notice, is it? NHI maybe, yes. Did you get the reference?
Yeah, NHI is before us. He is also NHI.
He is NHI. In this, he is NHI.
He is not aware about the order passed in his.
Because different standing councils are appearing for that. Different councils.
Madam had Filpa Shah had appeared, maybe, I don't know.
I am appearing for MD Kini, my lord.
Issue notice.
Please, my lord, I have applied for a stay, my lord. Execution is proceedings are pending, my lord.
The detail of that earlier matter, which notice have been issued, will.
Please, my lord. Till that time, stay may be granted, my lord.
This is different. This is different. We'll give a short date.
Please, my lord.
Serve it on them.
Execution proceedings are
When are they posted?
coming week.
We'll give after 2 weeks. You get them. Let us see.
Please, my lord.
You can tell the execution. That's correct. That is for the purpose of section 4. Tell us one thing.
Please, my lord.
Under the National Highways Act,
Yes, my lord.
the Land Acquisition Act doesn't apply.
Land Acquisition Act doesn't apply, my lord.
Doesn't apply.
No, under
So
the
enhancement is only under 3G5.
3G5.
Only under 3G.
3G5. Because now under the new act, it has been made applicable as far as the compensation.
That's right.
That is under the new act,
That's right,
my lord.
because of the schedule.
Because of the schedule, my lord.
Schedule.
Yes, my
No,
lord.
why we are concerned is under section 18 of the Land Acquisition Act, now I think section 74 is it? 74. There is a period of limitation prescribed for a land loser to seek redetermination. Here there is no period prescribed against. Example.
Bring to that order.
What is the Limitation Act? Sorry, this is a 43 of arbitration.
Also, that day we had done it. 43. The Limitation Act shall apply to arbitration exercise.
Correct. That's right. I also remember.
My lord, in one of the matter considered by this honorable court in T Unis versus National Highways Authority, reported in ILR 2012 Karnataka,
Right.
wherein it was held that having seen all the three acts of Arbitration Conciliation Act, National Highways Act, and Limitation Act, no period of limitation has been stipulated seeking a reference under section 3G5 of the National Highways Act. In such circumstances, the only provision available to the parties is to invoke Article 137 of the Limitation Act.
Where is
which
that
provides-
shows that?
I'll furnish that judgment maybe.
Give us a citation.
suggestion I will submit. Can you pass over, my lord?
You are reading from where?
Reading from my appeal grounds, my lord. I have stated in my appeal grounds, page number 10, my lord. ILR 2012 6055. 55.
6055.
Yes, my lord.
I also vaguely remember saying that, Tala. We issued notice on Stala. Notice is ordered. Proviso to National Highways Act. Looking for it, not able to find it. National Highways Kodi avarge. Maybe they can find something which extra ilva. You have National Highways Act. You don't have. You didn't carry the book.
I carry arbitration.
Read the Kodi.
Paragraph 12, my lord.
थ्री इयर्स में होल्ड कर दिया.
Hold कर दिया. Division bench has already taken the view, but those provisions have not been examined. The residuary provision in the Limitation Act, Article 137 is applied. So the doubt we are getting is that 3G5 for enhancement, you see that provision, 3G5, no period of limitation is prescribed.
But that has been considered. Yeah.
That has been considered, but not in the how we are looking at it. In a,
No, but it has been
it has
said
been
that
considered.
it has not been prescribed in 3G5, but the Article 137 of Limitation Act will come into play.
No, it can't come into play because
And 3-year period.
no, it can't come into play because National Highways Act doesn't say that Limitation Act is applicable. So unless National Highways Act says Limitation Act is applicable, we can't get that into National Highways Act.
But it does not bar it. It does not bar it.
No, the question is whether Limitation Act would apply
With
to
residuary-
all enactments.
Ah,
All enactments
unless it is specifically barred.
excluded.
So 137 is the residuary, that is all for that purpose. This is a correct way.
That's correctly said.
Unless it's specifically barred, Limitation Act will apply. And for that only 137 residuary power is provided. So the division bench has rightly taken this view that in view of the residuary power under 137, limitation period will be of 3 years only. So this is the view taken by the division bench of this court. Even if no limitation is prescribed under G5. 3 years.
But they said
And
that
that is the view taken
there's
by
one more principle. When a statute doesn't prescribe a period of limitation, then reasonable time principle is there. Now, the National Highways Act doesn't prescribe a period of limitation. So can we import this Limitation Act into the National Highways Act?
Limitation Act has meant for that only. 137.
No, sir, whether the act applies or not.
I agree that
3G5 doesn't.
has been held here. We cannot disagree.
We can't disagree. We'll examine. But heard learned will issue notice and states. We'll say that he's relying upon this. Refer to this and we'll state.
34. They have applied that only, no? 3 years only.
Correct.
What is wrong there?
No. The defense of the national hearing is rejected.
Why the guy?
So we'll have to stay there. We'll have to issue notice to the claimant. Claimant is the respondent. Yeah. This is what we had. Posted along with this. Third learned counsel for the appellant and peruse the material on record, after having heard the learned counsel for the appellant and on perusal of the material on record, aware of the view that the issue involved in the present appeal is identical to the issue involved in MFA 7120 of 2021, which now stands posted to 8/6/2022. Accordingly, list along with MFA 7120 of 22.
It is the order, execution of the order, my lords.
In the matter, there is no stay.
In that, we are not granted stay.
Please, my lord.
Rajendra NS.
Where the appellant is a leader pursuant into agreement with the claimants. The civil works contained into the agreement. Difference of opinion and claim is challenging the order passed by the suit as well as the award passed by the arbitrator. The of the claimants is that they have paid excess payments without any material basis to that effect, and the arbitrator has gone by the statements made by the claimants without they have not produced any documents in support of the payments that they have made. Comes to the conclusion that there is an excess payment, and the same was challenged before the in the suit, and when that has been confirmed, my lords. Now, what has happened is claimants have suppressed the fact that they had suffered a confirmation order at the hands of the BBMP before invocation of the arbitration clause. In fact, this claimant terminated the contract. Sorry, this appellant, who is the builder, he terminated the contract since it was very difficult for him to go on with the construction work.
The 19th order.
Correct. Grounds are taken with regard to amounts. Evidence has not been considered. Same usual grounds. Relevant evidence not considered. Based on no evidence, claim is upheld. Those are all now.
Not be considered now. There is very limited scope. Can we reappreciate the evidence?
Patent, my lords, because there is no finding on that, my lords, sir.
Law is very well settled now. You know it. On what ground the court can interfere under 34? That has been given in the section itself.
Order comes out of the assumption that they have paid. Claimants have paid is the assumption, and that assumption they proceed, my lords.
You'll have to, from the arbitral award, you'll have to show some glaring mistake.
Patent illegality.
The arbitral award.
In the patent illegality against the public policy, give the act, Competition Act, why you take it away?
Page number 39, the issue, my lords, issue number 3. Whether the claimants prove that they have paid the respondent rupees 67 lakhs 50,000 towards construction of the agreement and in excess of the amount agreed as award.
What is the finding on issue number 3?
Issue number 3, there is no finding, my lords. He simply says
No.
that I have admitted the amount.
Partly in the affirmative.
Partly in the affirmative, but in the reasoning section.
They claimed 67 lakhs 50,000. The tribunal grants 57 lakhs. Right. Please show us the reasoning on issue number 3 and as to how that reasoning is incorrect.
Here, my lords, page number 60, my lords. Last paragraph.
60,
Page
come
number
come to
60.
issue number 3 first.
Page
Finding
number
on
60.
issue number 3 is on which page?
Page number 60, my lords. Last paragraph. I have admitted it.
Just one to
Where
four,
is that admission?
Again, the respondent in his pleading, despite disputing the receipt of 7 lakhs at the pre-construction stage and another sum of rupees 3 lakhs and design fee, however, has admitted the receipt of 67 lakhs 50,000 in all.
Where is that admission?
It is not a
Admitted
statement
meaning
of
where
what
in your
that it has-
statement of defense you have admitted, is
I
it?
have not admitted, my lords. That is the appeal. So, against this, I should not an appeal before the before
admitted the receipt of
I received, I admitted 27 lakh 50,000 is what I have received.
not a statement of what had received the amount of 10 lakh.
Sir, this finding, respondent in its pleadings is show me a statement of defense. One second.
Receipt of ITNA cannot consider payment made towards civil construction work. So it leads to say that what the payment has paid the respondent towards construction agreed upon is only ITNA and not ITNA. So deduct the statement of defense that is
I admit to the extent of in the claim statement, I have filed counter claim where I have said that 27 lakhs 50,000. I admit and I claim that 15.5 lakhs has to be given to me. There is due from them. So they are filing it. They have filed execution proceedings and they are proceeding.
And all that the
Respond. Issue emergency notice to respondent number 1. Respondents. List of.
Yeah, 369.
Issue notice to respondents. List after service of.
on the delay as well as to notice responded on the application for condonation of delay as well as on the appeal.
Fiction. We had seen this last time. Vaisak time. Last time, Vaisak time. Last. Yes. Can apply. I mean, as if that except in so far as.
Integrity of application is raised in this matter.
Dispute between brothers resulted in filing, elder brother filing a commercial dispute, not claiming a sum of rupees 2 crores 81 lakhs 46,812 on the premise that he executed certain subcontract work. No such document was produced. The only the blemish on the part of the defendant is written statement not being filed on account of settlement process which was invoked, and that is born out of records. You must have produced memorandum of understanding, registered as memorandum of understanding. To substantiate that there was a settlement which was going on as at that time. Notwithstanding, a summary judgment is delivered by the court below without even an application being made in this.
Maintainability. Maintainability 2 of 21. Which file 91?
But I have read this application. That application for the present I am not facing.
Not facing.
For the present, my lords, I am not facing that application.
For the present means what? Whether it is maintainable or not.
Principal content is if my lordships are pleased to admit this appeal on the premise that without a my lords an application, summary judgment is delivered. May I invite my lords kind attention to page number 74.
It is not summary, ex parte.
Someone produced.
The defendant did enter appearance.
Correct, but if he doesn't contest also, it is ex parte.
How you have applied 91 CRPC here?
Not, this document is a per se created and a fabricated document. In respect of which I cannot, since the document is produced in evidence, I could not directly file a private complaint.
How 91 CRPC will apply here? 91 CRPC can apply here.
Section 91 CRPC application will dismiss. Not maintainable. How is it maintainable?
In respect of documents which are tendered or produced in a judicial proceeding, the court which is seized the matter only will have to initiate proceedings. But that application is now made requesting this honorable court to consider the contentions of the defendant who is the appellant.
Whenever any court or any officer in charge of a police station considers that the production of any document or other thing is necessary or desirable for the purposes of any investigation, inquiry, trial, or other proceeding under this code, under CRPC. That is 340, whatever complaint the civil court can make, that is different. The application will reject. Not a summary decree.
My lord's kind attention to page number 74.
Correct. That we have 74.
Once, my lords, in the present, when the defendant is, my lords, very much.
Why did you not contest? Why did you not contest the suit?
There was a settlement process in vogue.
Correct. If madam agrees, we'll send it back. Shall we remand it back to trial court? Give him one more opportunity.
The respondent has already entrusted this matter to the senior counsel. So requires some 4 days time.
Last date also you said.
Last time also you
So it was, they were about to appoint now, he has already entrusted the file.
We'll note down your request and we'll adjourn it. Counsel for the respondent, released in June 22. Interim order granted earlier is extended till next date of hearing. IA number 2 of 21. Rachekar.
Heard on
IA 2 of 22, you withdraw.
I'll withdraw.
Okay. Not press.
Dismissed as not. That's Learned counsel for the appellant submits that on instruction submits that the appellant does not intend to press IA number 2 of 21. Submission is placed on record. IA 2 of 21 is dismissed as not pressed.
Super level, Deepak Bhaskar.
Right, you have to be appellant. Notwithstanding the fact that the esteemed senior counsel has the right to pre-audience, may I please seek the lordship's indulgence in order to be able to apprise this honorable court of the disputed.
You had mentioned some urgency in the matter.
On the last occasion, I pointed out to your lordships, matter pertains about 71 cars, which the trial court has now directed them under section 9 to hand over person, the title in respect of which is lies with me. And now those are all cars which will depreciate unless they are immediately taken back. The claim of the other side is for parking charges, which itself is in dispute. So, drawn your lordship's attention to page 368 of the
request.
Correct. That's right. Let him argue.
The impute order is needed.
Sir, I think, don't you think it's better you come a little more to the center?
Second order, my lord, is dated 8th November 2021, Annexure A. My lord, the appellant is a platform which sells, my lord, which facilitates the sale of pre-owned cars.
The respondent, my lord, is engaged in the business of selling pre-owned cars. The mechanism devised between the parties is this, that the respondent, my lord, avails credit, avails financing either institutionally from banks or from private financiers, buys cars, here's, my lord, the loans that have been obtained, then sells it through a platform like me. Once I purchase it, I have the right to resell these vehicles. Now, the respondent's contention, my lord, is that 71 of these cars, which have been placed with me, are not for the purpose of resale, but have only been parked with me, my lord. That is not the case. Title is in dispute because I have paid valuable consideration for these cars. That is the submission I've made before the learned trial court, which is not being considered. My lord, may please have the impugned order, page 32.
33, para 3.
May I please just take my lord?
Applicant had allotted 64 cars to the respondent. You are the applicant. He is the applicant.
Please.
He is the applicant.
Please.
He allotted 64 cars to you.
Please.
They were parked in the Bangalore stockyard. In the beginning, they asked you to hand back 64 cars.
Please.
Then you asked for security.
Please.
Where is the agreement between you and him?
Please, I will demonstrate. My lord may please have the agreement dated 24th October 2017. It is at page 116.
100?
116.
Is this the only agreement?
My lord, there are subsequent addendums. The material particulars are captured in this agreement. Sorry, my lord, it's at page 88. The addendum is at 116.
Shows the principal agreement.
It's at page 88.
Page
88. Let's take the lordships to the relevant clauses. Clause 3B at page.
One second.
Please.
You are described as service provider.
That's correct. D-Best Cars India Private Limited. I am described as a service provider.
The preamble says you operate an online and offline auction marketplace.
That's correct.
Right. And then it also says the company, that is the respondent,
Please.
is in the business of providing self-drive cars.
Please.
Service provider, you approach the company with the request to provide services. So the company appoints you as a service provider.
Please.
What are the terms and conditions?
Please, my lord, we come to clause 3B, the scope of work.
1 second. Assignment, so on. Right. 3B.
3B,
the company
page 90.
shall provide details willing to sell through the service provider.
Please.
What is your right over the vehicles?
Please, my lord, what happens?
No, under the
Yes.
the agreement,
Yes.
what is your right over their vehicles?
Please. I will demonstrate.
Vehicles belong to them.
Please.
Right.
My lord, may please come to clause 8, which deals with this, page 96,
Right.
which deals with ownership of the vehicle.
Right.
May I read out that? The service provider hereby confirms that the second-hand vehicle shall at all times remain the property of the company, that is,
Right.
property of the respondents, till the time the company has received the minimum guaranteed price of the second-hand vehicle, and the second-hand vehicles have been transferred in the record of the transport department in the name of the buyer. Therefore, ownership vests with them until I have paid this minimum guaranteed price.
No, let's understand this.
Please.
The service provider hereby confirms that the vehicle at all time remain the property of the company till the company receives the minimum guaranteed
Please.
price. So till the two conditions. One is they have to receive the minimum guaranteed price and it is transferred in favor of the buyer.
Yes.
Till
Please.
both these conditions are satisfied, it belongs to them.
Ownership. Yes. Now, my lord, my submission is this. Once I make the minimum guaranteed price, since they have obtained loans to purchase the vehicles in the first instance, what happens is they take my minimum.
Till it is transferred to the name of the buyer, is it?
Please. So, my lord, they utilize.
And the minimum guaranteed price is paid by you.
That's correct.
Till then, it belongs to them.
Correct. So they take my minimum guaranteed price, clear off any outstanding debts because the financier will have a charge on the
We are not really on we're only on. Is it under this agreement, are you entitled to hold on to their vehicles?
Yes, my lord, there is a transfer
Where
of
is
title.
that?
No, my lord, clause 8, my lord, facilitates that. It says the service provider hereby confirms.
Right.
Second-hand vehicles shall at all times remain the property of the company
Correct.
till the time the company has received the minimum guaranteed price.
No, two things. One is, till the company has received the minimum guaranteed price from whom? From you.
From me.
Right. Then, second condition is vehicle has to be transferred in the record of the transport department. Till both these conditions are satisfied, it belongs to them.
Please. Now, my lord,
it belongs to them. If it belongs to them and these conditions are satisfied, not satisfied, you have no right to retain it, notwithstanding whatever your claim is against them.
my lord, my submission is this. The second leg of clause 8, which speaks of the transfer of registration, your lordship has, and the second-hand vehicles has been transferred in the record of the transport department. That is an action they have to facilitate.
Sir, it's not about that. It's about your right.
No, please.
See, whosoever has to do it doesn't make a difference.
So, my lord, my specific contention against them.
Right on you.
Please.
Where is the right created in the vehicle in your favor?
Please. No, if I may take your lordship through subsequent correspondence, which then alters the understanding. It alters the understanding captured by way of this agreement.
This agreement is novated, is it?
It's, my lord,
Altered, is
that
it?
is one of the specific pleas I've taken in the appeal, that the terms of this
Not the
agreement.
appeal. In your, where are your objections
Please.
to the Section 9 petition?
My lord, we get that. Is a connection C to this.
Section 9 only.
9 only.
Not arbitration proceeding. Correct. Court has seen the agreement. It does not confer any right to hold the position that
You have
May I,
and proceed against them if you want.
please, may I just take my lords through one email, page 357.
Right.
This is an email dated 20th October 2020. What happened, my lord, was post-COVID.
whether the arbitrator entered into reference.
My lord, we have filed a CMP, which is to be listed next week, I'm told. My learned friend has also filed a CMP.
With consent, see, with consent, we can appoint right now. Number one, you hand over the vehicles back to them. Urge all contentions before the arbitrator.
But my submission, if I may be.
Without prejudice, you hand over, not in compliance of the trial, commercial court order. You hand over the vehicles without prejudice. We'll appoint an arbitrator. Go before there and put forth all contentions.
May I say that an independent receiver may be appointed since the question of title itself is in dispute.
There is no question of receiver. You do not have any
Arbitrator will
right.
decide that also. All contentions, arbitrator will decide.
Well, now, may I please just read
The
this?
value of the vehicles would get depreciated. Let them use it. You know the value, right? As on today.
Please.
If you know the value, put forth a counterclaim or a claim, whatever you call there, before the arbitrator, and whatever loss you have suffered or incurred on account of whatever breach committed by them, you recover from them before the arbitrator. Let the vehicles go to them because under the agreement, you have no right.
No, if I may.
Over the vehicle.
You cannot hold the position.
You can't hold the position of the
No,
vehicle.
I follow what your lordships are saying. May I just be permitted to read this one
Only a
email?
service provider cannot, there is a platform. The service provider suddenly is now saying.
No, may I please be permitted to read this one email, my lord, one
Sir,
paragraph?
Don't get us wrong, but earlier, they used to have one small board, real estate, paper, cars, motorcycles, one small shop.
Please,
This is the same thing as that, right?
my lord.
And the vehicle will be parked outside.
No, I appreciate, my lord. Either this has to be a transfer of movable property or a bailment. And if it's a bailment, I have to return the property. I follow.
Whatever monetary claim you have against them, you put forth before the arbitrator.
No, my lord, it's not only a monetary claim that I have. I have claim to the title, which I want to read out, my lord, this email at page 357.
According to you, this email creates title in the property in your favor.
Please, because it novates how the parties are to transact.
Sir, this email is written by who to who?
This email is written by one Hemant Aluru, my lord, who is a senior manager of the respondent company,
Right.
one of the directors of the appellant company.
How can that create title? How can the
कैसे change कर देगा?
So, my lord, we just see this, my lord.
the email will not create rights, sir? How can the email create a right?
So the email may not create right, my lord.
Of the contract, correct.
My lord, but the email, my lord, the email alters the conduct expected of each party in respect of the maintenance of these cars. My lord, may please see paragraph 5 of the email.
very difficult to come to the conclusion that there is a contract, there are addendums to the contract. All those addendums and terms get altered
by email.
So,
email.
my lord, this is specifically in the context of the pandemic, my lord, where of course parties are not able to execute agreements. If I may please be permitted to read paragraph 5, my lord, after that.
Even assuming that there is some commitment made by one of their
Yes.
officers, it will not bind the company.
No, it is made.
Or vary the contract.
No, my lord, there are a series, it's not just a question of an email.
This email cannot novate, alter, vary, modify, or amend the contract in terms of section 62.
Fair enough. My suggestion is this, my lord, that
what's the point reading this?
the point of reading this, my lord, is that post this email captures the fact that the contract, the main agreement, was kept in suspension, that both parties agreed not to act as per that agreement, and they adopted an ad hoc mechanism.
Then if that is so, then restitution you will have to give back the cars, sir. Whichever way you look at it.
No, my lord, they have captured the fact that I have paid over 4 crores. 4 crores has been paid.
That's not, whatever you want to claim against them, go before the arbitrator and claim it. Don't hold on to the cars. It's of no use. You want to hold them at ransom and at whatever you say, gunpoint, and for the purpose of compromise, we understand. Strategy, all that we understand. But legally, what does it mean?
My lord, it's certainly not for the reason of compromise.
For interference.
Since, my lord,
Either we simply dismiss it.
We'll dismiss it.
Or we'll appoint an arbitrator, go there and
let them get the point.
No, sir. CMP.
Why we will make this CMP infectious?
3 names, but he will not. I did not answer one. I said you take any of the 3 minutes. I have read the CMP, then there are he has read the CMP, but he seems to be more not as your lordship not put it. This is a method not to try to settle the matter by untwisting us, but by holding back the cars.
But I bow down to your lordship's suggestion. An arbitrator may be appointed, an interim arrangement may be worked out insofar as the possession of those cars is concerned.
No, we'll confirm this order, and we'll say that the handing over of the cars as per this order will be without prejudice to the rights and contentions in the arbitration proceedings. Please tell us a name. Learned Senior Counsel has given 3 names.
Just have a look at I have filed an application with the subsequent notice which you have issued. But in that application, your lordship find page 11, I have suggested 3 names, any not all. I mean, your lordship has not any. An application which is filed.
That's right.
Under order 40, page 11, your lordship find 3 names.
We got it.
Please, any of.
You can choose. I think B may not be either A or C.
Not a.
Okay. 4127 application. 4127. Page 10. Page 11.
There is an application which is filed not under order 41.
41 rule 20.
Please.
A2.
With the notices on your open. But 2nd February not appears.
We got
Please. Lordship, Jesus.
A is okay for you? Right. This appeal by the respondent in commercial A number 138 of 2021 is directed against the impugned order dated 8/11/2021 passed by the LXXXV Additional City Civil Judge, Bangalore, whereby the application filed by the respondent dash applicant under Section 9 of the Arbitration and Conciliation Act 1996, for short the said Act of 1996, read with Section 6 of the Commercial Courts Act 2015, for short the said Act of 2015, was allowed by the commercial court. Was partly allowed by the commercial court, thereby directing the appellant to hand over possession of the 71 cars belonging to the applicant dash respondent on or before 2011-2021. Heard learned counsel for the appellant and learned senior counsel for the respondent and peruse the material on record. Full stop. Though several contentions have been urged by both sides in support of their respective claims, it is jointly submitted by on behalf of the appellant as well as the respondent that both the appellant and respondent have preferred CMP number dash and the CMP number dash. Just give both the CMP numbers dash respectively before seeking appointment of a sole seeking constitution of a arbitral tribunal comprising of a sole arbitrator in terms of the agreement dated 24/10/2017 and the addendums thereto executed between the parties. Full stop. By the impugned order, the commercial court directed the appellant herein to hand over possession of 71 cars in favor of the respondent. Full stop. It is, however, submitted by both sides that the order, Srinivas, order has not been complied with so far. They have not handed over. Has not been complied with and correct. Have not been handed over, and the said 71 cars continue to be in possession of the appellant as on today. Full stop. Next para. In view of the fact that the present appeal arises out of proceedings under Section 9 of the said Act of 1996, coupled with the fact that both sides have given their consent for appointment of a sole arbitrator, without prejudice to the rights and contentions of the parties, and leaving open all contentions to be urged before the arbitral tribunal, we deem it just and proper to appoint Shri A.V. Chandrasekhara, former judge of this court, as the sole arbitrator to adjudicate upon the dispute between the appellant and the respondent. Full stop. Accordingly, we deem it fit and proper to dispose of this appeal without interfering with the impugned order passed by the commercial court and by issuing certain directions in this regard. Issuing certain directions with regard to reference to arbitration of the dispute between the parties. Full stop. In the result, we pass the following order. Appeal is disposed of without interfering with the impugned order passed by the so-and-so. The appellant is hereby directed to number two, without prejudice to the rights and contentions of the parties and leaving open all contentions, the appellant hereby undertakes to hand over possession of the 71 cars as directed by the commercial court in the impugned order on or before
month's time.
On or before 1/5.
We'll go to their place and cooperate because a month's time again it.
How long does it take?
There are about 3,000 odd cars. So we have to identify this lot.
They'll get the list.
Please.
This is already before the court.
1 month will be an outer limit.
On or before 20th May, subject to on or
May not be 1.5 months.
20th April. I meant 20th April 2022. Subject to the respondent furnishing the list of the aforesaid 71 cars together with registration numbers, details, etc. to the appellant in advance. Full stop. Both parties have given consent. Full stop. In view of the consent given by both parties to refer the dispute between them to arbitration, we hereby appoint Shri A.V. Chandrasekhara, former judge of this court, so and so, as a sole arbitrator to enter upon reference and adjudicate the dispute between the parties. All rival contentions urged by both parties before the commercial court, this court as well, commercial court as well as this court are kept / left open to be adjudicated by the arbitral tribunal. Full stop. It is further made clear that the handing over of possession of the aforesaid 71 cars by the appellant and taking of possession of the same by the respondent would be without prejudice to the rights and contentions of the parties. Full stop. Subject to the aforesaid direction, the appeal stands disposed of.
One submission, I could have pointed this out earlier. Of the 71 cars, my lord, they themselves say they own 64. 7 are owned by third parties. This is their.
No, if it is documented and they have given it to you,
yes,
on as per document, just give it back.
Please.
But that.
An agreement came to be entered into Malad for the railway works of strengthening of 11 old bridges in the city area. But the agreement is dated 12/2/2019. And I have to repair the slabs and push it under the old bridges in the city area. That is the scope of the work. Malad, due to heavy traffic and there is no space in between for the standing of the train. I could not take up the works at 9 locations. At out of 7, 3 locations I have completed the work. In 8 locations,
Sir,
now 12.
What to do?
Not review of the notices and the repeated
No. This is section 9. Now you have a panel of arbitrators. Railways has a panel of arbitrators, isn't it? Right. So as per what is that? Clause 64.3, general clause of general conditions of contract.
Once I give a notice under clause 64 of this, the GM has 180 days.
That litigation, all those disputes with regard to whether they have forfeited their right, whether this court can appoint somebody else, all that is pending before a larger bench of the apex court. That core case is pending before, so we will not get into that. With consent, if both of you agree, we'll appoint somebody. Or we'll have to keep this appeal pending.
Section 9 has been discussed.
Section 9 has been discussed. We have granted interim order that they should not encash the FDR. Railways has their own panel. If he is ready, we can appoint somebody from the panel. If you are ready, we can appoint somebody from the panel.
I am ready.
No, from their panel. Are you ready?
From their panel, I am not.
That's what I said, sir. If you are not ready from their panel,
for me to file CMP, the time has now ripened.
sir, we'll appoint. The previous matter we did it, we'll appoint right now. If you want somebody from the panel, we'll appoint right now, if you're ready. If you want somebody else outside the panel, apart from 64.3 or whatever the general conditions of contract, then we'll have to keep this pending.
Section from my department, I'll make my selection.
What instruction you want?
No. There. No, because some matters, the railways have agreed for appointment of a sole arbitrator. That's why we are asking.
So the question before in this matter, my lord, they're not challenging the termination notice.
Not on it's section 9.
Please, my lord.
It's only because now what he's saying is that he has issued a notice.
Please, my lord.
Now time has come to file a CMP, so he'll file it. Till then, don't encash the FDR.
Next time, my lord, what is the details of the arbitrators in panel?
Please exchange.
Please, my lord.
One retired engineer, is it?
Please, my lord.
One retired engineer, one sitting engineer, one work. What is where is the 64.3 I'll put in.
64.3 is that it is part of page 160, 160, 170, 170 is
64.3A2. Panel of 3 gazetted railway officers, so and so retired.
What happened is.
No, sir, if you are not ready for this,
Subsequently, they have amended this to say that if I agree for waiver of 12 serving officer, if I.
correct, this is the old one.
Therefore, there is a slight modification over this. And my submission is in some of the matter, I have said that the amendment is carried out to class 64 of GCC itself is not in accordance with section 12.5.
That's right.
That takes away my right.
That's right. That's
Therefore,
right.
I am not.
That very issue with regard to eligibility and disqualification of the arbitrator under the schedule is pending before the larger bench. So we thought by consent, if you can appoint, we'll appoint. Both of you get instructions. We'll attend it. June we'll post it. In the meantime, please get instructions. At request of learned counsel for the respondents, relist in June. Interim order granted earlier is extended till next date of June.
Number 13, Mr. Kumar, you.
Defendant Sakil, my lord. Cabinet is a manufacturer and exporter of industrial stars. The respondent's services were engaged for forwarding and custom clearance of the.
We wanted to refer it to mediation.
Yes, my lord.
That's the reason.
Present on that.
He is not of the reply notice itself.
Sir, we wanted to refer it to mediation. We refer it to mediation. If both of you give consent, we can refer it.
Because he has admitted in.
Last time he said ready.
Yes, it is such a small amount.
Refer it to mediation. Or you want to sit across and talk and
Refer to mediation.
right.
Deposit करा लो.
Deposit. I don't know. Here.
Mediation final थोड़ा करना है लोग. It has to come out.
Come back.
Before,
Okay, na? ಒಂದು ಆರ್ಡರ್ ಮಾಡಿದ್ದೀವಿ ನೋಡಿ ಬೆಳಗ್ಗೆ serial number same order as in 50% in 3 weeks. One more matter we have. Let him deposit 50%. In 3 weeks it will be referred to mediation.
Date for mediation.
Date,
we will give the
we'll
date.
give a date.
After
Serial
3
number
weeks.
serial number 4 alla
21-4.
you were there in the morning.
Yes, I was.
Raghunath, MD Raghunath's matter 21-4 correct 21-4 same day.
The outcome of the mediation shall be
No, Your Lordship, sir, it never occurred to me that we should, otherwise we will not be serious there.
Serial number 14. Yeah.
Seriousness nahi hoga udhar.
14,
Serial number 14, my lords, I appear for the petitioners and also in the connected matters, my lords. This pertains to the challenge.
One second, madam.
Yes.
Please go ahead.
14,
Serial number 14, my lords, I appear for the petitioners along with the connected matters, my lords. This belongs to the batch of matters challenging the Karnataka minor mineral concession rules, amendment rules of 2016, my lords, which was segregated on the basis of the land falling in 3 different areas of ex-Mysore, Hyderabad and ex-Bombay, my lords. As far as the lands in ex-Mysore area is concerned, the matter has already been, the judgment has already been passed in writ petition 58505 of 2016, my lords. The instant matters before my lords is of lands belonging to the Hyderabad area, for which I believe, my lords, there's already a connected matter pending before this honorable court. If I may be allowed to give the numbers, the matter may be connected and a date may be fixed for hearing, my lords.
List,
Yes.
list along with so and so. Please pass it on.
Please, my lords. Writ petition number 8365 of 2017.
At the request of so and so. 8365 of 17.
2000, please, my lords. Obliged.
Number 50. Sorry, my lord. I may be permitted to carry out amendment here itself, my lord. I could not be able to place out.
We'll give you time. Petitioner is permitted to carry out physical amendment in main petition as directed earlier. Give a date. Within 1 week. Give a date. Any urgency in the matter? And then give it in June. Do it 1 week, the matter will come up again in June.
24/6, please. Number 16.
The respondent.
Muvattai.
Pending before the Supreme Court.
The matter is the matter is in Supreme Court. Pending before the Supreme Court.
Matter.
With regard to CA and NR.
NRC and CH, we have challenged certain problems.
Yeah, what is that?
CAA. Amendment. What's the point keeping this pending? Let the Supreme Court decide.
Please.
It should be adjourn it also, isn't it?
Oh, there's nothing.
Like, we want adjourn it, we'll dismiss it. Right. In this petition, petitioner is sought for the following reliefs. Full stop. Heard and command term. Having regard to the fact that the issue involved in the present petition is seized by the apex court.
Drawing the attention of the court. Drawing the attention of
Is drawing the attention of the apex court, comma, the present petition does not survive for
The specific order.
1 second.
drawing attention of the apex court and the decision of the apex court would determine the relief claimed in the writ petition. As such, there is no need for us to adjudicate the matter. The writ petition is accordingly dismissed.
After the disposal of the petition, any relief is required, liberty will continue.
The liberty is, it is needless to observe that the petitioner is at liberty to raise the issue after the decision of the apex court.
Not in all these, the first two matters, my name may be shown.
In fact, his name should be showed in broad.
It's not because my predecessor name is there, my lord, in the clause list, therefore.
Registry to print the name of Sri H. Shanti Bhushan for respondents in all the matters and delete the name of the other counsel.
Grateful.
Two matters, 16.1, 16.1.
Same.
17. Here, Mohan. Here for the third respondent. Okay, for the this matter pertains to the shifting of transformers on the footpath, Parliament Way and other place, school, near the school, and there was a direction of the report to file action plan report, 23rd December. Last order. I appear for the third respondent, Discom.
You had to submit action plan.
Please, my lord, I have the letter of intent, my lord, given to the successful tenderer. But may request for some time to file it, my lord, in the registry today.
We are not concerned with your successful tenderers or whatever it is. We are concerned with the shifting of the transformers from the footpath.
Please.
And all the
What you have done for that?
Yes. After the order of passed by this honorable court, my lord, on 23rd of December 2021, a tender was issued only for the purpose of shifting of transformers from the footpath. But the successful bidder then, my lord, the L1 had quoted 56% above the tendered amount. Therefore, my lord, the negotiations took place. And after failing the negotiations, the tender was recalled and yet
Last time we have said action plan shall be submitted.
Please,
Within what time you will shift it, that is all. Otherwise, we will summon all your authorities.
my lord, as
That is all.
one submission.
First, you do the wrong things, that you put the transformers on the footpath and put inconvenience to the public and put the public at risk. And now you are telling us about the procedural problems and all that we are not concerned about it.
Now 18 months.
We want the shifting of the transformer. We are repeating this thing.
Now a period of 18 months is given, my lord, to the successful bidder to shift the entire transformers identified by both BBMP and Viscom. And
Who has given 18 months period? You have given.
In the tender, my lord, the contract entered into the.
Why you have given such a big period? I thought we done in.
Basically, December they have produced the tender document.
That tender document was recalled. Yes.
More than 5,000 and odd.
As recorded in the previous order, my lord, there are about 5,245 transformers in the Viscom circle to be shifted.
Last time, this is what you have said. 5245 are to be shifted. That takes time. 2 agencies have been identified. Work order will be issued. Have you issued the work order?
But that tender, which is referred to in 23rd order, has been recalled, my lord. And therefore, subsequently, one other work order is issued on 17th.
You will have to summon your authorities.
May request for some time. I'll place all these subsequent
You are
developments.
not serious in shifting of the transformers.
The work has already been entrusted, my lord, to the contractor on 17th of March 2022, my lord. May we permitted to place all these developments on record, my
No,
lord?
we are not concerned with your development. We are concerned with the shifting of the transformers.
In fact, last week,
Enough time has been given to you.
2 deaths have taken place.
You are not interested in shifting. We will summon the managing director of Viscom.
May request for a passover, my lord.
Sorry.
On one hand, litigation is increasing because of
We are
deaths
not
by
at all satisfied
electrocution.
with the
Petitions
explanation
are
given
filed.
in delay.
2 people have died last week, your lordship. The transformers.
The execution
My lord, may I make this
of
submission.
work regarding shifting of the transformers from the footpaths. And in spite of sufficient time granted by this court, the shifting of transformers has not yet started. The delay in shifting of transformers affects the public at large, as all these transformers are installed on the footpaths and put the public at risk and also causes inconvenience. Let the managing director, respond number 3, managing director Viscom, we appear before the court to explain the reasons for not getting the required transformers shifted expeditiously. List on, give a date. Next week.
We just make one submission. Your lordships will not pleased to record that there is a delay in commencement. The work has already been commenced.
The report was supposed to be filed. That's what the order of this court has been.
Letter of intent is also issued, my lord.
Reading the article.
Pursuant to an order passed by this honorable court, produced annexure A, my lords. An inquiry was scheduled at the annexure L, a notice dated 22/10/2019. And we have filed objections to that. And that has not been disposed of so far. And this is pertaining to deemed forest issue, which this honorable court has categorically held that the question of deemed forest is a non-issue because it is nowhere it is provided. And I had already, my application is earlier to 2013 and revenue NOC is obtained, forest NOC is obtained. Still, I have not granted a query. Whereas as per photographs, I have produced an annexure Q at 114, my lords. Two other queries at respondent number 7 and 8 are granted in the same outcrop of the building stone. And my area or wherein I had applied, that has not been granted or excavated so far, which has not been granted to me. Page number 114, 115, 116, my lord. The photographs very clearly say that the other two persons, one respondent number 7, Francis Joyce. I'm sorry, respondent 7 is Praveen Hegde and 8 is Francis. Their area is shown here, my lord. And they are still operating. Whereas my area is shown at page number 114, which is still unexposed or unquarried. Nothing prevents them to grant me query these matters. Herein the question of deemed forest doesn't arise.
Question as to whether it is a forest or forest land. As per the decision of the Dhananjaya's case, produced at page number, the relevant portion is 37 and 38. The authorities are inquiring into plans. We will take a decision within a time-bound manner, not since it involves the forest issue.
We will dispose it of. We will dispose it of.
Please.
Observing that they will consider the relevant legal position on the issue, whether it will be a deemed forest or
forest.
It has already been issued. Issue has already been decided by law, and photographs will very amply show there is no.
On the basis of photographs, we can.
Have you not decided?
No, even the forest NOC, I have produced my laws. Forest NOC
is this petition. Petitioner is sought for the following reliefs. Full stop. Heard. It is the apart from other contentions put forth in the petition, it is the grievance of the petitioner that despite the earlier round of litigation in WP 1837 of 2017, dated 2/7/2019, wherein certain directions were issued by this court, coupled with the law laid down by this court in the case of Dhananjay versus State of Karnataka and others, and connected matters, WP 54476 of 16, dated 12/6/2019, wherein it is held that there is no concept of deemed forest for the purpose of granting quarrying lease, the respondents are unnecessarily protracting the matter and not taking necessary steps to grant quarrying lease in favor of the petitioner who is before this court by way of the present petition. Full stop. Per contra, learned AGA submits that if reasonable time is granted, the respondents would take necessary steps.
Sorry for interruption, my lord. that notice has already been issued and inquiry has already been initiated. For the last 2.5 years, they have not taken
It is
any
also
initiative.
pointed out that,
That annexure L, my lord.
that though the respondents have issued the requisite notice dated 22/10/2019 to the petitioner, notice as long back as on 22/10/2019, the respondents are not concluding the proceedings and are not taking any decision in this regard. And as such, the petitioner is before this court by way of the present petition. Per contra, if reasonable time is granted, the respondents would take appropriate decision and pass appropriate orders in accordance with law. Submission of learned counsel for the learned AGA is placed on record in view of the aforesaid fact and circumstances and the submissions made at the bar. We deem it just and appropriate to dispose of this petition, directing the concerned respondents to consider the application of the petitioner for grant of quarrying lease and take appropriate decisions / pass appropriate orders, bearing in mind the decision of this court in Dhananjay's case, Supra.
In Dhananjay's case,
in accordance with law, within a period of 4 months from the date of receipt of a copy of
in Dhananjay's case, it is not held that there is no concept of deemed forest. What is held is, in the light of Godavarman's case, the authorities have to inquire whether it is a forest land or forest land. That is all. Your last may kindly see.
No, paragraph 18.
Paragraph 19 is operative.
We make it clear concept of deemed forest appears to be foreign to the law.
Yes, ma'am.
That's what we have said. Anyway, it doesn't matter.
If paragraph number 18 and 19 are very clear, my lord.
All right, only.
Please, ma'am.
Number 19, J.R. Mohan.
This matter pertains to the widening of Bellary Road. There is a direction issued by this court on 10th March 2021. And after the
What happened before the
application,
application?
Application is moved, it is yet to be considered, my lord. That was moved on 12/8/2021 itself. We have moved an application seeking modification of the order before the Honorable Appellate Court.
You are not pursuing it, no?
My lord, we are, my lord. Now that the physical hearing is permitted.
Putting the public at large in difficulty because of your.
But the only issue there was giving TDR. Otherwise, earlier 2 occasions, we had moved the application before the Honorable Appellate Court. And if we are granted
but all the things that you watched, this court observed on 10th March 2021, para 7, 10th March. Notwithstanding the fact that they moved the application.
Is there any chance of your application being considered?
Certainly, my lord. My lord, now that the physical.
Kindly see 10 or
2 earlier occasions we were.
Then find an alternative, but that's what the order passed on 10th March, para 7, you want.
That AG informs on the basis of instruction that the IA preferred in the civil appeal number 3303 of 1997 is pending consideration before the apex court, which is likely to be considered shortly. On his request, case is adjourned today, list in the month of June.
No, date. Date, not required. June. List in June 20.
20. Chira Ravishankar.
Amendment is not carried out.
Right, objections.
Amendment. Petition is not carried out.
To appear for petitioner.
Right, objections. Right of CL11 license.
Pass over.
Number 21.
Lord, I appear for the respondents.
Fine for the petition, my lord.
Madam, filing memo, compliance of remaining cases, my lord. My colleague is there before the court.
remaining 7 cases.
7 cases, my lord, 5 has been disposed of. The remaining 2 cases are not pending. I don't know how they have made that. Out of 7, my lord, 5 has been disposed. The 2 not pertain into the caste certificate cases. All cases are cleared by the DCBC, my lord, as of now.
May I make a suggestion, my lord?
Shall we keep this petition pending for 2 cases more?
No, my lord. These cases are pending for the last 25 years, my lord. The last 25 years it was pending. And according to my client instruction, my lord, 13 cases are still pending, my lord. So that I will clarify by the date of next date of hearing, my lord.
All right. We'll give them one more chance to finish up with the remaining 2 cases.
Yes,
The respondent informed that out of the 7 cases which were left for disposal, 5 cases have been disposed of, and now only 2 cases remain.
It is not pending, my lord. My submission is the 2 cases which they have referred, there is no pending such 2 cases before the court.
No such cases pending now.
No. DCBC, there is no case pending. All cases are cleared. I have stated in my memo.
My lord,
by the District Caste Verification Committee, Kolar, the remaining 2 cases are not pending before the District Caste Verification Committee, Kolar. Full stop. The statement of the counsel for the respondent has also been placed on record by way of memo dated 31st of March 2022. Same is taken on record. We'll dispose of the petition.
No, according to my client instruction, there are 13 cases are pending, my lord. So I have to cross-verify whether the statement made by the government advocate is true or false, madam. Maybe given one chance, madam, to file a rejoinder, madam.
Every time I have served a copy on him.
He wants to look at it and file.
That's what I got an instruction, madam.
We have accepted their statement. Now we have said in case the position is otherwise, then we will give you liberty to move an application for modification of that.
Whatever.
In view of above, the petition appears to have become infectious. It is accordingly dismissed as infectious. The liberty is given to petitioner to move appropriate application for recall or modification of the order in case the statement given by respondent is found to be false.
Madam Lords, it's a case pertains to the coming appointment of chairman and members of the PDA. When the our objections are yet to be filed, a short accommodation finally, Lords, because it is.
You are delaying the things. Why you are delaying it deliberately?
No, Lords, I'm not, Lords. A short accommodation, Lords. Next week, Lords, we will file it. Not much.
Who appears?
We have filed our objection for the 5th respondent, 4th respondent.
State has to clarify, my lord, whether this appointment is in accordance with law or not, according to the BDA Act.
Whether a sitting MLA can be whole time chairman, this was the issue.
That is the issue. My lord, in my submission, my lord, a sitting MLA cannot become a full-time member because of the provisions of the Constitution of India and also of
the rules of procedure.
Who has appointed?
Appointment is done by the government, state government.
Government has to defend it. Let them file the statement of objection. There will be the learned AGA informs that the statement of objection on behalf of respondent number 1, 2, 1 and 2 is under preparation. What do you say? It is ready. He will file the same within 3 days. On his request, case is adjourned today. Give a date.
I'm appearing for the petitioner in serial number 23, Your Lordships.
Yes.
Your Lordship, in the previous time, we have sought for time to file the rejoinder. Your Lordship, we have applied for certain documents. Your Lordship may kindly accommodate a week's time to file our rejoinder, Your Lordship, in this matter.
On the request of counsel for petitioner, case is adjourned today to enable him to file the rejoinder affidavit list in the month of June. Last week, June.
Obliged, Your Lordship.
Number 24.
This matter in pursuance of the order passed by this honorable court, Learned Chief Secretary has appointed Principal Secretary one Mr. Rajendra Kumar Kataria as the inquiry officer in this matter. He has been conducting inquiry, but he would complete the inquiry within a week. Therefore, I am filing an application for extension of time. Each time may be time.
Learned AGA appearing for respondent on the basis of instruction submit that pursuant to the court's order dated 14th of February 2022, the Chief Secretary, Government of Karnataka has appointed whom?
Mr. Rajendra Kumar Kataria, Principal Secretary,
to conduct inquiry and submit the report. The inquiry officer will complete the inquiry and the report would be submitted before the court on the next date. Full stop. An application for extension of time to complete the inquiry filed before the placed before the court by Learned AGA is taken on record. The 2 weeks time is granted to the inquiry officer to complete the inquiry. The inquiry report shall be placed before the court on the next date. Give a date.
My submission, my lord, on the last date, it directed in the last sentence that the inquiry shall cover all other lands as well. So not only with regard to the petitioner. I'm not sure that will be possible in 2 weeks because as far as we are concerned, we have been called for the inquiry. So that inquiry is going on.
Shall we extend the time?
Yes, my lord. Maybe they may be required to take somewhat in question. 2 weeks.
It is all the leaders in the state. We have to call for records from 31 districts.
Clarify that maybe
4 weeks, make it 4 weeks list in the month of June.
Or in
the alternative.
Para 12 of our order. Para 12 of our order.
Because it involves 3 departments. Revenue.
With respect to all such cases where mining has been permitted on forest land or any other land which are not permissible mining purpose.
It will take a long time.
That may be restricted to the petitioner because
We'll modify this and say only.
What is that?
Because preamble. The Lordship sees para 10 and
purpose was to stop. Let the pressure.
So that.
Not to this case. This is only an example.
Yes, subject why I'm a little apprehensive, having appeared extensively on the other side. I'm fairly certain that report will take another 8 or 10 weeks. In the meantime, my cases will keep getting postponed. That's my only apprehension.
Let some improvement in the working.
Well, of course.
be done.
You may have to transpose yourself as respondent. So moto PIL.
May grant at least three months flood so that we complete everything.
Exactly my apprehension.
So that
An application again.
please.
We have said in June. Okay. Lot of pressure.
Applications. Application for extension of time.
Allowed.
The month of
June. Last week of June.
First week of June. So, whereas my only application is an application for deemed extension, and that will keep getting postponed. And
Let the report be submitted.
Yes.
You may hold the inquiry in part. With respect to petitioner, you may first submit the report and thereafter you
We'll clarify it. We'll clarify it and say that in the first instance, the inquiry officer shall submit a report in relation to the subject line of the petitioner on or before the next date of hearing, and thereafter comply with the directions issued in paragraph 12 of our order dated so and so within a period of 3 months from today. Realist first week of June.
Great.
25, Sagar BB.
Section A minutes is the application minutes made by the petitioner for grant of quarry lease license minutes for granite. Minutes, this application minutes is made on 24th April 2015. Minutes, even after the lapse of 2 years, minutes, the application was not considered. So the petitioner minutes was before this honorable court minutes in repetition number 216 of 2017 at annexure B minutes, page 27. The said writ petition minutes was disposed of, directing the respondents minutes to consider the application in accordance with law. Minutes, by the time minutes this order was passed, the 2016 amendment minutes had come into force. Pursuant to which minutes, annexure C minutes, they have issued an endorsement saying that minutes, the application of the petitioner minutes has become ineligible. Thereafter, minutes, in a series of writ petitions minutes, the validity, constitutional validity minutes of the amended rule minutes 8B was changed. Minutes,
find a statement of objection.
Not statutory remedies available against this order. But this order is passed in pursuance of the order passed in Tirumala's case. We have considered all the paragraph 47 of Tirumala's case and passed this impugned order.
If a lordship were to see minutes, the
This
operative
matter we have already dismissed on the ground of alternate remedy.
Yes.
Where is that order? You already dismissed some. Same order you have passed in other matters also, which had come before us, and we have probably dismissed those petitions.
Rule 53, alternate.
On the ground of alternative remedy.
Yes.
Revision.
Give that order.
Revision minutes.
Same.
Minutes, the endorsement that is included in the writ petition minutes is a consequence minutes of the orders passed by this honorable court. Minutes, if I am able to demonstrate to your lordship minutes that there is no complaints of this order, then minutes the writ petition, irrespective of the remedy of alternate remedy minutes, this writ would lie minutes. Thrice minutes, so the writ has been entertained. Now minutes, there is a specific order of this honorable court minutes at page number 268 to consider minutes if the application of the petitioner minutes would be under the saved provision. They simply say that minutes application is dated 24/4/2015. Minutes, the deemed fiction minutes was introduced in the year 2013. Minutes, the amended provision minutes 8B has come into force only on 12/8/2016.
In spite of that, they say that the law doesn't provide for that deemed fiction of deemed NOCs. Under the unamended rule 6.
Take a different view.
Non-compliance of the earlier directions, we've already said that under identical circumstances, alternative remedy, we have done it. So for us to distinguish this,
I'll go through the judgment and sometime.
I'm not available. You only said that in view of the alternative remedy available, equally efficacious alternative remedy under Rule 53. Now, we also did it.
There are
several orders.
Orders are already passed.
They already passed. That is the problem. Otherwise, we could have.
Right. Last week or 2 weeks back.
Again passed.
Right. In this petition, petitioner is sought for the following reliefs. Heard. Though several contentions are urged by the petitioner in the present petition, having regard to availability of equally efficacious and alternative remedy by way of filing a revision petition before
the
Joint Commissioner, Department of Mines and Joint Director, Department of Mines and Geology, under Rule 53 of the said rules, so and so rules, 1994 rules, we hereby dispose of this petition, reserving liberty in favor of the petitioner to avail such remedies as available in law, including preferring the revision under Rule 53 as stated supra. Full stop.
Also stand on the same footing, lots. My applications for renewal of lease, lots.
Deemed extension.
Kindly peruse the order dated 28/1/2020.
Where is the judgment?
I'm producing.
It's covered by the judgment only.
Para 9 and 10.
But it speaks about the prospective lease and the lease lots. My application is for renewal lease, which is not covered under 8B lots, with my humble submission. Rule 8B only refers to lots, the prospective lease or the lease. Mine is an application seeking renewal of the lease which was already in existence. And lots
8A.
8A lots, it is only with regard to the tenure of
all the
lease.
minerals which have been classified.
Renewal has been rejected, which has been determined or lapsed.
Yes.
It is
Three
only
categories.
it is only confined to lots by respective submission is lots.
Which is confined only to
Rejection of renewal.
Rejection or determination of lease lots is confined only to 8A is my humble submission lots. So far 8B is concerned lots, it refers only to the lease, grant of lease. Mine is an application seeking renewal of lease lots. So far as
1 second, let's understand what is the distinction you're trying to make. Rules code. Let's read 8A first. 8A4 is it? What was urged in that?
But it refers to the period of all the lease or licenses of non-specified minerals except the mining leases of the minerals now classified as minor minerals granted before the date of commencement of the Karnataka mining.
So on the basis of this provision, the other petition was filed. Sub-rule 8 was referred to by us. Please read sub-rule 8. The provisions of this rule, that is section rule 8, shall, notwithstanding anything contained therein, shall not apply to a quarrying lease or license or mining lease of minerals now classified as so and so under the government, for which renewal has been rejected, determined, or lapsed. What had happened in your case?
Not in my case. Renewal of the application, renewal of leave, not my application has been rejected.
Correct.
My respectful submission.
Therefore, plain reading of Rule 8A8 says entire Rule 8A doesn't apply. Right.
I don't fall under 8A for this reason.
Right. Then show us under which rule you fall under.
Not I fall under 8B.
8B.
Status for application, which refers only to the leases and not the renewal of leases, because there are certain
Sir, 1 second.
exceptions.
All applications received and pending for grant of lease.
You
applied for grant of lease, is it? 8B, 8 cap. You applied for grant of lease.
Renewal of lease.
Renewal, not grant.
Not grant.
How it will be covered in the 8B?
8B for new application.
It is only for new application.
It sets out certain categories which not.
Shows the word renewal in 8B.
It be specifically with respect to the new license. It does not talk about the renewals. 8B is not attracted. Your case is only under 8A. 4.
And the non-obstante clause in 8AB, 8A8 has been interpreted as excluding any right created under 8A4. That's the position.
Notwithstanding.
Notwithstanding.
This judgment will totally cover your
Cover
case.
it. What to do?
Earlier, my lords, no objections were issued by the same authorities. Subsequently, my lords.
Coordinate bench, we have already taken a view.
The question as to whether the application for renewal of lease deed is rejected prior to amendment in the Karnataka Minor Mineral Concession Rules 1994 and whether it can be treated to be saved application has been considered by this court in the judgment and order dated 24th of February 2022, passed in the case of K.M. Ramaswamy versus State of Karnataka, WP 18739 of 2021, GMMMS. The court has held it as under for the
There are 13, but the date of application and rejection.
paragraph 13, 14, 15. The questions involved in the present petition are squarely covered by the aforesaid judgment. We therefore dismiss the petition.
The question as to whether the renewal application rejected prior to 28.
The question as to whether the application for renewal of lease deed rejected prior to amendment.
Right.
This is what we have said.
Actually, academically, the issue was not with regard to saved as such. The issue was if a major mineral is reclassified with effect from 12/8/2016, whether 8A8 will apply or not.
Not only that, there are three.
That is what we have said. See, we have interpreted this
in that
8A8 as reclassification. A mineral is a major
we have
mineral.
covered the entire thing.
In that case,
I don't know. Just 1 second.
Yes, covered the entire thing.
No. Shows that
In which
in rule 8A8,
yes, in that notification, all major minerals, 31 major minerals are reclassified as minor minerals.
Reclassified, right?
Yes.
Now you read. So it is a case of reclassification.
Yes. That is one of the category.
No. On 10/2/2015, there is a reclassification.
Yes.
Major minerals were reclassified as minor minerals.
Yes.
Right. Now read 8A8. Not your case. Generally, we are just.
The provisions of this rule, notwithstanding anything contained therein, shall not apply to quarrying lease. Quarrying lease is
They're not on categories. Shall not apply to quarrying lease or license or mining lease.
Or mining lease.
All right. Of minerals now classified as minor minerals.
Yes.
Under. That means if the notification was not there,
yes,
it would remain major mineral.
Yes.
If the notification. Because of the notification, it becomes classified as minor mineral. Now, a mineral which is a major mineral, which is reclassified as a minor mineral, only those that category, that small number of those, that category of minerals, 8A8 will apply. If it is from S.
Not only that. That is why I am reading this. There are three categories.
Sir, we are not on categories of the license and the lease. We are on the category of the mineral. A mineral is a major mineral.
That's true. That is large part of this. There are three categories. May clarify this. Quarrying lease or license or mining lease of minerals now classified.
That's what, sir.
Quarrying lease means
minerals were major minerals. See, 8A4 gives a right.
8A4 gives a right.
A right.
Right for already minor minerals as well as
whatever right is given. We are not getting into whatever right is given. We are only on the applicability of the non-obstante clause. Non-obstante clause applies only to those minerals which were classified as major, reclassified as minor. In respect of other minerals which were not classified as major and subsequently reclassified as minor, 8A8 will not apply.
It will apply.
You please read, sir.
That is why I am submitting.
Please read that provision.
The provisions of this rule, this has been interpreted in common cause also.
All right. Anyway, for present purpose, academic discussion.
By reducing only one para in common cause.
All right, we'll consider in some other case.
We are only looking, since you cited this, we are just academic exercise.
Renewal of lease, not lease in respect of a minor.
Your case is covered by this judgment. By this judgment, unless it is set aside.
All four matters.
27, Satish K.
Review.
Yes, I will not be petitioner. Appointed as Bishop Deputy Commissioner. Karnataka Land and Yes, on 27/5/21. Let us see page 47.
What is the contention?
Contention is not this code.
That KS officer should become
Section 9 of
Lord, Act itself, a special deputy commissioner can be posted as Lord to exercise the power, all power. The court did not notice section 9. Lord, one more thing is Lord, election F is quashed in this case. Kindly take for a moment Lord the order passed by this court, election A. For the petitioner, Lord, in fact has.
We will hear the matter on some other date.
I wanted to bring your lordship notice.
Supreme Court has.
Yes, sir.
We remember. We remember that.
It is not my.
My only submission, as per the direction of the government notification itself, person who had to initiate the procedure.
All right, the matter is to be heard.
Yes.
We will hear it.
The non-existent order is first. The very order is a fabricated order.
With the
I
consent
put
of
that.
Party Council,
Election F.
he is waiting to the list in the that will be listed. April. April will have to be by the Supreme Court direction.
18th April. 28. Sridhar Prabhu.
But give a date. Give it. Date.
How come Sridhar Prabhu is not there? Must have gone to KERC.
Passover.
Passover matter. Bill number 2.
I appear for the appellant in this case.
Your lordship are not present.
The case pertains to.
So for appellant.
Yes, ma'am. Yes, ma'am.
Yes.
Please, ma'am.
Yes.
This pertains to transaction with regard to unauthorized shares purchase and transfer. I had relied on certain documents which I had produced before the tribunal. The documents have not been considered. On the contrary, the tribunal has misinterpreted a citation or a declaration of the Calcutta High Court, wherein the Calcutta High Court, sorry, my
Yes.
3 courts have held tribunal, appellate tribunal, section 34. What is
Yes.
it we can do?
The reason being, the Calcutta High Court, in its declaration,
We are not from the Calcutta High Court. We want to know as to what is the illegality in the impugned order from last week. You have
Please.
not been able to get any favorable order.
may I draw your lordship kind attention to page 48, my lord.
Yes.
In 48, clause 3.2 of the regulations, part A.
Yes.
I would read from paragraph 2 of that clause, my lord. In spite of these provisions, unauthorized trades were being carried out. Therefore, for prevention of unauthorized trading by stockbrokers in the year 2017 and 18, 3 circulars were issued by SEBI, which came into effect on so and so date. The circular dated 22/3/2018 states that SEBI in the past has taken several steps to tackle the issue of unauthorized trades with periodic running account settlement, post-transaction SMS emails by exchange depositories. May I just pause for a minute, my lord? The SMS were sent to the customer immediately upon the transaction. These SMS documents have not been considered by the tribunal. In fact, post passing of this award, I have also deposited the entire award amount. In view of not considering the document which I have produced,
to substantiate my claim, contention, to show that he had, in fact, was aware of the transaction. And further, the circular reads as under my lord.
That's the content.
My contention itself has not been considered either by the authority or the appellate tribunal, nor the district judge. In fact, the district judge has wrongly interpreted the declaration of the Calcutta High Court, which was actually in my favor.
1 second. If the ground is that SMS has not been considered by tribunal, appellate tribunal, and 34 court, can we consider now? Venkatesh Murthy.
Please, madam.
SMS produced by you before the tribunal have not been considered is one of the main grounds, is it?
Yes, SMS and the login details, my lord.
Right. Where are how many of them? Bunch of documents or how many?
Bunch of documents, my lord.
Where they marked?
Because no, my
where
lord. No, there's no concept of marking the document before that authority, my lord.
You have anything to show that you produced it?
Yes, my lord. I will produce it.
Now, has it been referred to? Has it been referred to in the tribunal?
Yes, my lord.
Please show us where it has been referred to. If it is referred to and considered, then we can't do anything.
No,
if it is referred to and not considered, then we can
if
do.
it has not been introduced before the court, and
show us where it is referred
to. Get it now.
SMS and login details.
Yes.
Please show us where reference to that.
May I draw your lordship kind attention to page 51, my lord.
Right.
May I please?
Yes.
The broker can inter alia show the same from SMS log, cash ledger log, and DAS and other available records. All these records were produced before the authority, by law. That have not been considered by the authority.
Produce the SMS.
Produced. You have produced it.
Yes,
produce the SMS message log showing the delivery of messages to the respondent contemporaneously.
So it has been considered.
So that how can we reappreciate?
No, they have not been looked into, my lord.
No, they have looked into it. A view is taken.
Whatever view is taken, we cannot reappreciate the evidence.
The further, the claimant has also produced SMS message log showing the delivery of messages to the respondent contemporaneously with the execution of the trades.
In the instant case, referred to in the present. Sorry, we'll dismiss. We dismiss.
May seek one indulgence.
There is nothing.
I will physically come and appear before you.
No, sorry. Not after arguing. Dismiss. We'll pass the order.
And in fact, the circular says these documents have to be looked into, my lord. The
That has
circular
been looked into by the tribunal. Yes. Next.
Number 20. Shweta Ravishankar.
Amendment.
2 weeks to carry out.
The case is revised. All this is being revised and appears for the petitioner to present his petition. As per order dated 9/12/2021, a week's time was granted to carry out necessary amendment in the cost item. It appears the fiscal amendment has not been carried out. 2 weeks further time is granted to petitioner to carry out the is an amendment in the cause title of the petition. List. Yeah.